There are two prominent principles underlining this natural justice. One is nemo jude in causa sua. Second principle is audi alteram partem. What is nemo jude in causa sua? First you write it down, then I'll. Nemo jude in causa sua. Nemo judex in causa causa sua. Audi audi not that car audi. Alteram alteram partem audi alteram partem. So nemo jude in causa sua means nobody should be judge. Nobody should be judge in his own case. Nobody should be judge in his own case. It's English translation. And audi alteram partem, the other party should also be heard. The other party should also be heard. Audi means hearing. Alteram means other party. Alteram partem means alternate party. This is right to hearing. Right to hearing. So no case should be disposed without hearing both the parties. Audi alteram partem. And no person should be judged in his own matter. That means it is a need for neutrality. It's a need for a neutral judge. Judge should be neutral. Means a neutral person should hear the case, number one. If a person is not neutral, natural justice will not be present. So here we see in case of kingship, the king makes law, and king executes law. Suppose king imposed some taxes, that imposition of tax so harsh, execution of that tax collection so harsh, people died of hunger. And common man approaching king, that, oh Lord, oh king, because of your tax, thousands of people died, my family suffered, died, my neighbor, I lost him, that, give me justice. Will king suggest, hang me? So if a person is not neutral, justice will not be there. It's a natural thing. And one of the recent example of this application of this idea, which comes into controversy concerning the advent of administrative tribunals. The tribunals are questioned on the grounds of this absence of principle of natural justice, this principle, first one, nemo jude in causa sua, because tribunals are manned by, or the members of tribunals are generally executives. Members of tribunals are members of that government body, like income tax related tribunals, income tax appellate tribunals. The income tax officers are members. Or Indian Railway Freight Tribunal. So person from Indian Railway Traffic Service, like you are appearing for civil service, you will find that in filling your DAF, you will find one service is there, IRTS, Indian Railway Traffic Service. So members of Indian Railway Traffic Service, they sit in Indian Railway Freight Tribunal, or other claims related tribunals of Indian Railway. Railway employees are the member, railway senior officers are the member. So Indian Railway drafted a rule, members of that service becomes biased towards that rule causes damage, people claim, then the members of railway cannot bring natural justice. Even if they are neutral in their conduct, people will not perceive them to be neutral. So judge should not only be neutral, it is said, a very important saying about judiciary, judge should not only be neutral, he should be seen to be neutral. I am neutral, but I am seen to be neutral. Like my son is fighting with my neighbor's son, and because of that, some damages to someone. My neighbor's son got injured, and I become the judge. Even if I do some justice, then people will not accept me to be neutral. If I take judgment in my son's favor that he got injured not because of my son, it's neutral judgment. He got injured not because of my son should not be punished because he is not the real culprit. Despite my neutral judgment, people will not accept it to be neutral because I am father of that child. So I am neutral is not sufficient. I must be seen as neutral. So judge should not only be neutral, he should be seen to be neutral. People must see that he is neutral. Same idea is applicable in case of administrative court, administrative tribunals. But there is need for technicalities. Technical expertise is not there with the judiciary, ordinary court members. Those who have there in the administration, they know the minuteness and the technical dimensions of administration. So they are the best person. They are the best person who can resolve the complex dynamic situations and issues. That is must. Despite this criticism that administrative tribunals do not follow the principles of natural justice or they negate principles of natural justice, despite that we need it. So we will study in next unit administrative law, we shall study about this point. But judiciary should be neutral. No, its principle is what? Judiciary must be neutral. And that is why nobody should be judge in his own case. Own means not person, means maybe organization, a department relating to some family. Concept of conflict of interest is related to this. And second thing is audi alteram partem. When we say other parties should also be given the opportunity of hearing. That if you look our constitution, article 311, the 311 gives protection to civil servants. If you read article 309, 30, 310, 311, 312, it's about civil service, union and state. 315 UPSC and UPSC related provisions. 316, 317, 318, 319, 320. So 311 says that no civil servant can be punished. Number 1, in case of removal and dismissal by an authority not subordinate to the authority who has appointed him. If president appoints, governor cannot remove. That we have discussed in executive control. And number 2, without given the reasonable opportunity of hearing. Means you cannot one-sidedly dispose a case, suspend a person, dismiss a person. Hear him. The so cause is given. So cause. It's a notice given to authorities. Why this happened? Why lapses? Why misbehavior? The so cause notice is given. Why? Hearing from that person. A very significant typical example of this particular principle. Recently one case came concerning Sabrimala. So in Sabrimala case, this Audi Alteram Partem was applied. How? Initially, Young Lawyers Association, a body, it came to court. It filed a PIL that in Sabrimala, woman is not allowed. Woman of puberty age is not allowed in Sabrimala temple. Why it's not allowed? Because Ayappa, it's a Ayappa Swami's temple. Ayappa is a son of Shiva, bachelor. He maintained celibacy throughout his life. So Ayappa Swami, a bachelor, the devotees believe that as he is bachelor, he would not be preferring a woman. So in the sanctum sanctorum, means the prime deity where Ayappa is existing, is placed, woman is not allowed. Because devotees believe that he will lose his celibacy, or in their thought, in their perception or their belief, the Ayappa Swami should be not worshipped by woman. Woman should not come in front of Ayappa Swami, they believe. But Young Lawyers Association put a case as violation of fundamental right, equality, right to woman, and Supreme Court given verdict in favor of Young Lawyers Association. And Kerala government, when first they denied that they will not execute, when they started executing, resistance came from the devotees. Matter became very serious that time. Then the devotees of Ayappa Swami, they had one trust, so they approached Supreme Court. They approached Supreme Court on what ground? On this ground, Audi Alteram Partem, natural justice. That Supreme Court heard the case of Young Lawyers Association, but they did not ask the view of the devotees. There are two parties. One party which is discriminating according to Young Lawyers Association or Supreme Court, discriminating, and other party is which is discriminated. So for discriminated party, organization came that their view was heard. Why not view of the devotees of Ayappa? So that was in Sabrimala when they took the matter. Supreme Court accepted the review petition. Hearing started. It was given to 5 judge bench to 9 judge bench, and now Supreme Court recently 1 year back said that they will hear all other issues concerning right to religion, like Zoroastrian religion, some woman related provisions, the Islam, some have some issues concerning that or what is denomination under article 25, 26 of the Constitution. So religious denominations. What is the public order and morality is a term. Exception to right to freedom of speech and expression. What is the significance of that morality term here? What is the scope of that morality term of Article 21A 2? So Supreme Court, this given to larger bench and verdict has not come. But the point is that no court can dispose of a matter without hearing the other party. If it is doing so, it is bound to rehear or appeal lies. So there is a thief in an office. He has a tendency to steal things. A laptop is stolen from that office, and manager assumes that, oh, this thief is in the office, so he should be punished, and police take him and punishes him. Or the manager expels him from the office without hearing him. Or a woman says a person, bad character person, sexually harasses someone. So person is bad character does not mean he should be punished. He must also be heard. Justice says that even if a person has been punished in the past, has a negative denominations or negative character, on the assumption that person can't be punished, hearing is must. It's a natural justice. Otherwise, justice will not be there. So this nemo jude in causa sua, this is not possible when king is the judge. When separation of power is not there, when clear-cut separation is not there, especially judicial separation, then first principle is not possible. Is not possible. And when some person who is not neutral, belongs to organization, body, etc., when he comes to power, when he takes charge of adjudication, then he may become biased. He may become prejudiced. The judiciary should work beyond fear and favor. No fear, no favor. And that is possible by separation of power. So separation of power is an idea, has its root in the principles of natural justice. Clear? And there, because of this, we see a judiciary existing. Existence of judiciary, why? Because of separation of power, because of principles of natural justice. What the point? The first part. The second part is why, or sorry, when judiciary intervene. Judicial intervention